The co-founder agreement should prepare co-founders for the worst case scenario. In case things don't work out, we still want you guys to be friends. A co-founder agreement is like a prenuptial agreement that you enter into with your co-founder. Why do you need a co-founder agreement, and what key terms should you look out for? Hi, my name is Rachel. I'm a startup lawyer and a fellow founder, and in this video, we'll be covering the purpose of a co-founder agreement, the key terms you should look out for, as well as the life cycle of a co-founder agreement. Divorce amongst co-founders is one of the top reasons why startups fail, and don't let that be you. What is a co-founders agreement? Well, in my opinion, a co-founders agreement is a short-form shareholders agreement, aka a baby shareholders agreement. In modern times, many startups fundraise using the YC Save or a variation of that. That essentially means that investors are not issued shares until a price round occurs. Key terms of a co-founder agreement. Just like marriage, it may be useful to have a chat with your partner before entering into an engagement with them. So what are the key terms you should discuss with your co-founder before starting your startup? The first issue that co-founders would have to agree on is the share split. Would it be a 50-50 arrangement or a 70-30, 60-40 arrangement? If indeed it is a 50-50 arrangement, you would want to make sure that there are good deadlock provisions in your co-founders agreement. This would ensure that the company will not stall in the event that the co-founders disagree on certain matters. The second issue that will have to be discussed is the terms of vesting. Founder shares are typically subject to reverse vesting rather than forward vesting. What this means is that these shares are issued first rather than issued after the vesting period has been completed. It is also important to set out clear mechanisms on how to take the shares back if these milestones are not met. The three common mechanisms in Singapore are as follows. Share buyback, which is subject to a 20% cap in Singapore. Share transfer, which can be transferred to perhaps another co-founder or an investor. And third, capital reduction. The third issue that a co-founder agreement should cover are restrictions on shares. As the younger sibling of the shareholders agreement, it should set out certain basic safeguards that the shareholders agreement would typically contain. For example, preventing share transfers unless the proper approvals and consents have been obtained, or preventing co-founders from mortgaging their shares. For more information on what you should need in a shareholders agreement, do check out our shareholders agreement video. Number 4. The co-founder agreement can also talk about the board composition and who is entitled to appoint members to the board. In the event there are 2 co-founders, and each co-founder can appoint 1 person to the board, it may be important to set up robust deadlock mechanism. For example, if the co-founders disagree, can one co-founder veto another co-founder's decision? And if co-founders do fundamentally disagree on many things, would there be a buyout mechanism? The fifth issue that the co-founders agreement should address is expectations and KPIs. Marriages sometimes fail because of the disjunct between expectations and reality. And this is a great forum to tell your co-founder what you expect from them. Number 6. The co-founder agreement should prepare co-founders for the worst case scenario. In case things don't work out, we still want you guys to be friends. Possible solutions include a buyout of the other co-founders' shares. Number 2, setting out clear mechanisms on when the co-founder should step down from the board of directors. And number 3, maybe having a soft landing, like a clause saying that, if things don't work out, I still like you, I want you to be a key advisor, but maybe not a co-founder. Finally, your co-founders agreement should also contain other provisions. For example, would a non-compete be applicable to your startup? The co-founder agreement should also contain terms like confidentiality, non-disparagement, as well as robust IP assignment clauses. Finally, we cover the life cycle of a co-founders agreement. Upon the occurrence of a prize round, the co-founders agreement typically falls away and is replaced by a more robust shareholders agreement. That does not mean the co-founders agreement is not useful, because it's truly an important document to get you from your honeymoon phase to your prize round, and it's an important protection for you in case there are any bumps along the way. Oh, and if you ever need a co-founders agreement, you know who to look out for. Spoiler alert, it's not the Ghostbusters. Who you gonna call? Ghostbusters! Sorry. Thank you for watching, and we hope you enjoyed this video. If you liked it, remember to like, share, and subscribe below, and do check out our other videos. Bye! Have a good day! See you!